we have some other elements that we have to prove, and then I'm going to come back and talk about acceptance. Okay. In any contract, we have to prove that both parties had mutual assent, which means they both had a meeting of the minds. The thing that I think I'm buying is the thing that Rob thinks he's selling. Now, you might say, well, that's kind of obvious, isn't it? Well, it's not always that obvious. Let's suppose, for instance, I walk into the classroom, I look at Rob, and I point over that general direction, and I raise one finger. Okay? Now, Rob thinks I'm talking about his pen. I think I'm talking about the book bag. I hold up one finger, you know, he thinks, well, I guess that means he's offering $1 for my pen. Yeah, okay, I'll go with that. All right. So he thinks he's selling me the pen. I think I'm buying the book bag. We don't have a meeting of the minds. We don't have mutual assent because what I think that I'm buying is not the thing that he thinks he's selling. And so we have to have agreement. Now, the best way, of course, to clarify that is to write out what's being bought and sold. But since most contracts can be oral, we have to have some way of establishing that we both are doing the thing that we thought we were doing. The other thing, of course, is consideration. Consideration is what I talked about already. Somebody's giving up something to get something. That one's hopefully is kind of obvious. We have to give up something to get something. That's what we call consideration. We have seen the phrase consideration used in deeds. We've seen it used all over the place already. This is the first time we've talked about it in a contract setting, but that's just a real basic requirement. I'm giving up something to get something. He's giving up something to get something. That's what keeps police officers from collecting on rewards. The next thing we have to talk about is the contract itself has to be legal, which means it has to have a legal, concept. It has to have a legal subject. So this prevents people who are dealing in illegal drugs from suing each other when they don't deliver. Okay, Rob and I have got a contract where he's going to deliver me a kilo of cocaine. And I'm going to give him 15 grand for that. Well, I show up my 15 grand and he doesn't have my kilo of cocaine. Can I sue him for that? No, I can't. Wait a second. It's a contract. We agreed to it. We had our mutual assent. We're very specific about what we're doing, and I'm giving up $15,000. He's giving up his cocaine. Well, the problem is you cannot sue somebody over any type of subject that is illegal by its very nature. The courts won't allow you to enforce an illegal transaction through a contract. So if we're talking about prostitution, gambling, illegal narcotics, any of those things, if you haven't got a contract with somebody about that, sorry, you can't enforce it. And hopefully that kind of makes sense. If it's already illegal and would get you in jail, you can't sue somebody over it too and say, hey, I want you to deliver my cocaine. The next thing we have to have is we have to prove that both parties who are engaged in the contract have legal capacity, which means they have the mental ability to know and understand what's going on. It does not mean that they have to have a really good deal. It just simply means they have to know and understand what's happening. If a person is mentally incompetent, they can't enter into a contract of any kind. Even if it's to sell a stick of gum or to sell a multi-million-dollar mansion, doesn't matter. If you lack capacity, which means you do not know and understand what's going on in the contract, you cannot enter into one. And so somebody who's been declared to be legally incompetent, and we'll talk about that next semester when we do real estate title searches, one of the things you always do is you check to make sure the seller has not been declared legally incompetent, because then the transaction is void. They can't sell their property if they are legally incompetent. What happens is the courts appoint a guardian ad litem to represent that person, and the guardian has to sign off on everything. Let's suppose this is near and dear to my heart. I'm going to probably have surgery sometime soon. My sister is my guardian for when I am under the influence of narcotics or under anesthesia or whatever. I am no longer able to make decisions. So if they come to me and ask me to do something, I have a healthcare power of attorney. My sister is a nurse. They cannot ask me for permission to do things to me, because the minute I'm under anesthesia, I lose that capacity. I'm now incompetent, and they have to go through my sister, who's a registered nurse, to answer those questions. Now, how do we determine if somebody has capacity? Well, it turns out in the law it's pretty simple. We always assume everybody has capacity. So unless we can show some reason why the persons engaged in the contract had reason to know the other person was cuckoo, well then we're going to simply assume capacity. And we always assume capacity, even if it's a bad bargain. Remember the dollar I just offered Rob a while ago? Suppose he sold me his book bag, and he's got $2,000 in cash in his book bag, and he knows it. So he's just sold a book bag for $2,000 plus his books plus whatever's in there for $1. Well, that's just a bad bargain. That's not even a good deal. Does that mean he has capacity just by its very that he lacks capacity? No, it doesn't actually. Even if he engages in a really bad bargain, it does not indicate incapacity. What we have to prove instead is before the transaction, I, as the buyer, or I, as the buyer, had some idea that he lacked capacity, or a court had intervened and said he lacked capacity. The fact that he just decides to sell his book bag for a ridiculously low price will not invalidate the transaction, even if it's an extraordinarily bad bargain. So we assume capacity unless and until somebody has some reason to know that the person lacks capacity. Okay, how can we figure out that Rob lacks capacity when he sells me his book bag for $1? As he's talking to me, he tells me he's Napoleon. Okay, now I've got a pretty good indicator that he probably has some type of mental incapacity issue. If I go through with the contract at that point, I'm now at a point where that is probably going to be invalidated later on. So put me on the stand and say, well, what did he say to you at the time of the contract? Well, he mentioned something about thinking he was Napoleon, but I didn't really, well, how was he dressed? Well, he was dressed as Napoleon. Okay, and he thought at the time that he was actually fighting against the French, and he thought he was selling me one of his regiments. In fact, it was his book bag. That's going to get thinner and thinner ice. They're probably going to avoid that, give me back my $1, and make me give back the book bag, because the buyer at that point had reason to suspect that the person lacked capacity. But if the person seems lucid and it's just a bad deal, hey, that's just the way it goes. Yeah, I saw that. Buys the desk for like a couple $100, right? And has $98,000 inside it. Well, that never happens to me. Just one time, but that person's relatives might say, well, the guy who sold the desk is obviously crazy. Why would he sell a desk at $98,000 in it? But that by itself is not going to be enough. Had the guy been ruled to be, mentally incompetent by a court before that happened, well, then the family's going to get the $98,000 back. But if the guy is lucid and he just forgot there's $98,000 in there, sorry, the guy with the new desk gets to keep the $98,000. Of course, I imagine the IRS has probably already contacted him about that $98,000, but that's a question for another day.